All right, friends, I am thrilled to have my friend and fellow legal analyst, Danny Cevallos, with us on Justice Matters.
Glenn, I am so honored to be here. The strange thing about this business is sometimes you get to be friends with the people you admire, and you are one of those folks, and you have been for a very long time.
I mean, when I watch you and I send you the little messages, it's
Yes,
because
means so much.
I love what you bring to the analysis game. And even though we'll talk about it, we kind of come at it from obviously two different backgrounds, but
Sure, sure.
we generally land the same place. But when you work in the cute turn of a phrase, it adds so much, in my opinion, to the analysis, because now you're entertaining people and you're sucking them in a little bit more, and they pay more attention to the
Right.
important part. And I'm telling you, I'm a big fan. I really am.
Oh my gosh, I mean, it couldn't be more mutual. Wow, I'm so flattered. So flattered. Thank you.
Couple of rapid fire questions. We know that Judge Aileen Cannon did an enormous favor, though, for Donald Trump by dismissing his classified documents obstruction of justice espionage case that has been appealed by Jack Smith to the 11th Circuit Court of Appeals. Does the 11th Circuit reverse Judge Cannon's dismissal and return it to the trial court and put it back on the trial track, or do they affirm the dismissal and the case goes away, or perhaps takes a trip to the Supreme Court?
I think the odds are they reverse. I think this case gets sent back. I mean, but certainly not before the election. I think it does, and here's why. I think for me, I distill it all down to not just one sentence, but maybe one word, and that word is dicta. And maybe you can tell me if I'm wrong. But the view that I have is that so much of Cannon's decision, not all of it, but a large part of it, rests on the idea that the Supreme Court in the Nixon case in the 70s, when they essentially gave the benediction to the special counsel, the law that continues to authorize special counsels, when she dismissed that as dicta, I think if the 11th Circuit even concludes that, no, it's not dicta, it hasn't been treated as dicta, there's plenty of evidence showing that it's not dicta. Maybe I'm wrong, but if the 11th Circuit at least finds that she was wrong about the Supreme Court's holding, then that alone puts her original decision at the district court in serious doubt. What do you think?
I agree. I would say it's more than dicta plus. Maybe it is a holding in the case -1. It is somewhere in that gray area, but let's face it. If special counsel or independent prosecutors weren't a thing, weren't lawful, I find it very hard to believe that the Supreme Court in 1974 would have leapt over that and forced the president to comply with a subpoena that was issued by a special counsel or an independent prosecutor. So I agree with you, Danny. They're going to reverse. Here is the next question. Is there any chance that the 11th Circuit Court of Appeals, if they reverse and send it back to the trial court, sends it back to a different judge, a fair, impartial, and independent judge? Might they do that sua sponte, in other words, on their own, without Jack Smith even asking for it?
I think I'm probably in the minority in that I don't think Aileen Cannon should be recused, either by motion in the district court or by the 11th Circuit. Look, as a defense attorney, I'm biased. I'm probably a little paranoid. I think that often I feel like a judge is always deciding every motion in favor of the prosecution. Of course, there's a pretty good alternate explanation for that. The government may be right, and I may be wrong. But still, I think absent any evidence that Aileen Cannon is actually biased in favor of Trump, other than her decisions. And Glenn, I'm sure folks could give me some compelling arguments that she is in the bag for Donald Trump. I just don't see it quite yet. I think recusal is a pretty dramatic effort or a solution. And I think our system is designed on the idea that we appoint federal district judges. Most of them are great. Most of them, in my opinion, are far superior than what we get when we elect judges. And I spend a lot of time in front of both appointed and elected judges. And so for that reason, I think the law can, I mean, look at this for example, the 11th Circuit may end up, and I think is likely to end up, reversing her decision. And in that way, the system works. I don't know that we're at the level of recusal yet, but I also think I'm in the minority, and I can totally see a reasonable argument for recusing Cannon and for the 11th Circuit doing so if they think it's particularly egregious. I just don't see that yet. And for that reason, I think it's been a wise move that the government, that Jack Smith's team, has not pushed for her recusal, at least so far, and maybe that'll change. But I just don't think we're at recusal yet.
All great arguments. My counter argument would be, and not surprisingly, we come at it from two different backgrounds. I think, first of all, it might make some sense moving forward that anytime a criminal, former president of the United States, is being tried, this is the first time it's ever happened, he or she ought not be tried by a person that he or she appointed to that coveted lifetime position as a federal judge. That feels like an inherent appearance of conflict that can easily be avoided. But then on top of that, Danny, and you know all of this, she was reversed once for abusing her discretion by the 11th Circuit Court of Appeals for doing something that they said the law does not allow. You can't interfere in an ongoing DOJ investigation. And she did, interfered, that was their word, in the investigation into the classified documents that were seized as evidence from Donald Trump. She put a stop temporarily to that investigation. She was reversed a second time. She then dismissed his criminal case in a way that I don't think the law or the precedent supports. 3 strikes and you ought to be out, but I agree with you. I don't know that the 11th Circuit will do it sua sponte on their own, and I don't know that Jack Smith is ever going to be moved to file a motion to recuse. So open question, and I think we're not that far apart on that one. Here's the last question with respect to Aileen Cannon. And the minute I saw that the would-be assassin at Mar-a-Lago, Ryan Routh, his criminal prosecution landed on the bench of Aileen Cannon. What are the odds? Talk about serendipity. So, Danny, do you believe that because I think we can all agree that Judge Cannon has engaged in enormously beneficial rulings to Donald Trump, even if you don't think there's enough there to remove her from Donald Trump's case if the 11th Circuit sends it back to her? What about the defense attorney representing Ryan Routh, who was engaged in an assassination plot, according to what we've learned, against Donald Trump? Should his counsel file a motion to recuse her because of what I would call the unduly cozy relationship she appears to have with Donald Trump? Should Routh's counsel file a motion to remove her from presiding over Routh's case because of her relationship with the victim, Donald Trump?
So here's where I'm going to sound like a complete hypocrite, and I totally accept that mantle, no problem, where I do think the defense should consider filing a motion to recuse. But that goes back to the defense attorney's sworn duty to try everything they can within the rules of ethics to zealously defend their client. And your question is kind of a two-parter. If they do not file that motion for recusal and Routh is convicted, then you better believe, I think you'll see that on appeal as an ineffective assistance of counsel on a 2255, on a essentially, a habeas type petition, that counsel was ineffective for not asking for recusal. So I may sound like I'm talking out of both sides of my mouth, but I do think the defense attorney's duty is to explore that as a possibility. And if they choose not to, and he's convicted, I think you'll probably see the issue come up on appeal. I think that, again, we just have such a unique situation where a judge appointed by a president, and by the way, your earlier argument, the appointment issue, I think is really a challenging one. We've just never had a former president involved in so many criminal cases before a judge including a judge that he himself appointed. So I don't know how we deal with that. But if you're Routh's defense counsel, I think you have to file that motion, or you're going to see it on appeal somewhere down the range.
And Danny, you anticipated my next question, which was the ineffective assistance of counsel question. So thank you for jumping out there and answering that. I agree. It would be a robust ineffective assistance of counsel claim that Routh would have. I'm not saying it's a winning claim if his attorney, for whatever reason, declined to file a motion to remove Judge Cannon from presiding over his case. Okay, one more legal question, then we're going to get to the fun stuff. Although I think this is also the fun stuff as far as I'm concerned.
Oh, yeah.
So, New York, Donald Trump's conviction. Someday, let's assume he is going to be sentenced. Do you think Judge Maran imposes a period of incarceration or not?
I think my answer to that is Slightly different to your question. I believe that he should not impose a sentence of incarceration. And I know that that comes from, again, my internal bias as a criminal defense attorney. Here are my points, I think, that mitigate in favor of at least a probation, maybe even a house arrest, something that is not actual true incarceration. Number one, the first-time offender. That, of course, as you know, in the federal system under the sentencing guidelines, is one of the major factors on the two-axis sentencing guidelines matrix. So he's a first-time offender. It is a felony that is the lowest level felony in New York. I am not persuaded by the fact that it is multiplied by, many different times and many different counts of conviction. In my view, although this may not be the correct view in terms of grouping, in my view, these are all kind of part of the same category of offense. So I would consider I would want to see them sentenced as essentially one of the lowest level felonies in New York. You have his age. You have all the traditional factors. If you use some of the factors in the United States sentencing guidelines, they're not controlling, but I think they're interesting. And that's why I love the sentencing guidelines. I study them like a religious text. I can't say I'm that knowledgeable about them because they're so complicated. But I think it's compelling that he is a first-time offender. I think his age is a significant mitigating factor. I think that because it's the lowest level felony in New York, just above a misdemeanor, I think, in my view, I forgot the most important factors. No guns, no drugs, no violence, no children involved. It is as straightforward a white-collar crime, I think, in my view, as you get. And I think for those reasons, he should be sentenced to a non-incarceration sentence. And I actually think Justice Merchan will sentence him to something approximating, whether it be house arrest. And by the way, house arrest, I think, is a good compromise. Probation, sure. I don't know how you would administratively handle house arrest for a presidential candidate or an actual president. I think constitutionally, the sentence is completely put on hold, even if it's house arrest, if he's elected, or more specifically, when he's inaugurated. But maybe Justice Merchan just sentences him to probation. It is the easiest from an administrative standpoint, although that should not factor in too much into whether or not to impose a sentence. But I really think that this is a good argument for a straight probation, or I guess technically time served, however you want to call it, sentence.
I am going to have to disagree with you, Danny. I know you're shocked by that, but here's the thing. This crime didn't involve violence, it didn't involve drugs, but it did involve, at least figuratively speaking, I think, violence to the democratic process, to our free and fair elections, and to the American voters, because, he committed these falsifying business records felonies, which the jury convicted him of, really to try to cheat and steal the 2016 presidential election. So I think it's in a category unto itself. I agree with you. I am a fan of the sentencing guidelines, and frankly, I shouldn't say I'm one of the few prosecutors, but I may be, who actually applauded when the federal sentencing guidelines went from mandatory to voluntary, because because before that, the playing field was unduly skewed in favor of the prosecution, in my view, and I think that's a minority view among prosecutors. But here's the other thing. If you sentence Donald Trump to home detention, you're basically sentencing him to live at Mar-a-Lago, binge watch Netflix, and order DoorDash, which is no kind of punishment for the crimes he committed, and no deterrent value to the next aspiring dictator who comes down the pike. I think the deterrent value looms large, and I think that is going to impact Judge Merchan, together with the 10 counts of obstructing or of contempt of court for just completely ignoring all of the rules and the orders of the judge. So I not only vote for, but I am leaning toward Judge Merchan imposing a sentence of incarceration. Now, will it be executed or suspended pending appeal? That's a whole nother topic for another day.